This is the Quiz Fix. I'm Cyril, that's Olivia. One true story per episode, one quiz at the end, because facts you tested on are facts you keep. Here we go. If you want a Supreme Court case that changed everyday life in America, Brown v. Board of Education is right at the top of the list.
Absolutely. It's one of those decisions people have heard of, even if they only know the basic phrase. Separate educational facilities are inherently unequal.
And that phrase became a legal and cultural turning point. But the story starts long before 1954, with segregation built into American life, especially in the South.
Right. After Reconstruction, states passed Jim Crow laws that enforced racial separation in public spaces, including schools. And the Supreme Court had already helped set the stage with Plessy versus Ferguson in 1896.
Plessy is the notorious one that gave us the separate but equal doctrine.
Exactly. In theory, segregation was supposed to be equal. In practice, it almost never was. Black schools were often underfunded, overcrowded, and supplied with outdated materials, if they had enough materials at all.
So by the mid-20th century, the legal and social pressure was building against that system.
And a big part of that pressure came from the NAACP, especially its Legal Defense and Educational Fund. Thurgood Marshall was the lead attorney, and he and his team pursued a carefully planned strategy to challenge school segregation in court.
Which is important because Brown v. Board was not just one isolated case. It was actually a consolidation of multiple cases from different states.
Yes, the lead case was Brown from Topeka, Kansas. But the decision also covered cases from Delaware, South Carolina, Virginia, and Washington, D.C. The court combined them because they all raised the same constitutional question. Can states require segregated public schools?
And the answer, unanimous answer, was no.
That unanimity matters a lot. The court's opinion in 1954 was written by Chief Justice Earl Warren, and the justices were careful to present a united front.
Which is interesting, because this was the court that would soon face enormous resistance. But in the decision itself, they were clear that segregation in public education violated the Equal Protection Clause of the 14th Amendment.
And they made a huge point about education itself. The court said education is perhaps the most important function of state and local governments.
That line is one of the most quoted in constitutional law.
For good reason. The court recognized that public education shapes opportunity, citizenship, and future success. So if segregation marks one group as inherently inferior, that does real damage, even if a state claims the facilities are equal on paper.
That gets to the psychological evidence that was part of the case too, right?
Yes, the NAACP and the plaintiff's side relied in part on social science research, including the famous doll studies by psychologists Kenneth and Mamie Clark. Those studies suggested segregation could harm black children's self-esteem and sense of identity.
Now, to be precise, the court didn't say the case turned only on psychology, but it did acknowledge that segregation's effects went beyond buildings and budgets.
Exactly. The opinion said that even if physical facilities were equal, segregation itself created inequality, because separating children by race generated a feeling of inferiority that affected their hearts and minds in a way unlikely ever to be undone.
That wording was powerful and also very measured. Warren's opinion didn't try to rewrite all of constitutional law at once.
No, it focused on education. That restraint may have helped the court reach unanimity, but it also meant the decision was both narrow in legal reasoning and enormous in practical effect.
Let's pause there for a second, because this is one of the key points listeners should understand. Brown did not instantly integrate American schools.
Definitely not. In 1955, the court issued Brown II, which told lower courts to implement desegregation with all deliberate speed.
And that phrase turned out to be a problem.
A major problem. It gave resistant states and districts room to delay. Some used legal maneuvers, school closures, pupil placement laws, and outright defiance to slow integration for years.
So Brown was the constitutional breakthrough, but enforcement was a different battle.
Exactly. And in that sense, Brown is both a legal victory and a reminder that court decisions do not enforce themselves.
The context of 1954 is worth remembering too. The United States was in the middle of the Cold War, presenting itself as the leader of the free world.
That's right. Racial segregation was a glaring contradiction to American claims about democracy and freedom. Internationally, segregation hurt US credibility, especially when the country was competing with the Soviet Union for global influence.
Not that Brown was decided just because of foreign policy, but the broader environment mattered.
It did. Still, the core of the case was constitutional, whether segregated public schools denied equal protection of the laws.
And the court said yes, even though Plessy had been on the books for decades.
Brown didn't formally overrule all of Plessy in one blow, but it effectively dismantled separate but equal in public education. Later cases and decisions extended that logic further.
Let's talk a little about Thurgood Marshall, because his role is crucial.
For sure. Marshall was a brilliant lawyer and strategic thinker. Before becoming the first black justice on the Supreme Court in 1967, he had built a long record of challenging segregation through the courts.
And he understood that changing the law required more than winning one argument. It required building a chain of cases, evidence, and moral pressure.
Exactly. The NAACP didn't just ask the court to react emotionally. They assembled a legal and factual record showing that segregated education was unequal in practice and in principle.
The plaintiffs themselves were ordinary families, though. That's easy to lose in the legal drama.
Very true. Brown v. Board was named after Oliver Brown, a parent in Topeka, Kansas, who challenged the school segregation his daughter faced. But there were many plaintiffs across the consolidated cases, each dealing with daily injustice in their own community.
And Kansas is a good reminder that school segregation was not only a southern issue.
Right. De jure segregation was most entrenched in the South. But school segregation and inequality affected other parts of the country too, through both law and housing patterns.
So when people hear Brown, they sometimes imagine a single neat before and after moment. But the reality was much messier.
Much messier. The decision was a legal landmark, but actual desegregation involved local school boards, federal courts, civil rights activism, and sometimes direct federal intervention.
One of the most famous follow-up moments was Little Rock in 1957, when federal troops had to escort the Little Rock Nine into Central High School in Arkansas.
Yes, and that shows how Brown depended on enforcement. The Supreme Court could declare the law, but communities that opposed integration often resisted fiercely.
That resistance took many forms, including the so-called massive resistance movement in some states.
And some districts closed public schools entirely rather than integrate them. That's how intense the backlash could be.
Which makes Brown even more remarkable. It wasn't just a legal opinion. It became a symbol of the broader civil rights movement.
And it inspired other challenges to segregation in housing, transportation, voting, and public accommodations, though each area had its own legal fights.
I want to come back to the wording of the decision, because a lot of people remember the quote, but not the reasoning. The court said that in public education, the doctrine of separate but equal has no place.
That's the line, short, clean, and devastating to segregationists' constitutional argument.
Yet, the opinion also leaves some modern readers wanting more detail. It doesn't walk through a long originalist debate or a huge historical survey.
True, and that's partly because the court was navigating divided precedents and a very sensitive social issue. The opinion was meant to be effective as well as legally sound.
There's also the role of Earl Warren, who had only recently become Chief Justice.
Yes, Warren had political experience as governor of California, and he worked to build consensus among the justices. His leadership was widely credited with producing a unanimous opinion.
A unanimous court sent a strong signal that segregation in schools was no longer defensible within constitutional law.
It also made it harder for segregationists to dismiss the ruling as a partisan or fringe judgment. That said, they still resisted it for years.
And the decision had ripple effects far beyond schools. Even though Brown was about education, it energized the modern civil rights movement.
Right. It became a moral and legal foundation for later victories, including the Civil Rights Act of 1964 and the Voting Rights Act of 1965.
So if we're thinking about Brown's place in American history, it's both specific and symbolic. Specific because it targeted school segregation. Symbolic because it signaled that the federal government could no longer tolerate racial caste systems in public life.
That's a great way to put it. It didn't solve inequality, but it declared that the law would no longer recognize segregation in education as legitimate.
And in terms of legal history, Brown is one of the clearest examples of the Supreme Court reversing a long-standing precedent when society, evidence, and constitutional principle all pointed in the same direction.
Yes, though it's worth remembering that the court doesn't move in a vacuum. Brown came after decades of organizing, litigation, and activism by Black Americans and civil rights lawyers.
That's an important correction to the myth that history changes only because judges decide to be wise one day.
Exactly. Brown is a landmark not just because of the opinion, but because of the people who forced the issue into the courtroom and then kept pushing after the ruling.
So, to sum up, Brown v. Board of Education in 1954 held that segregated public schools are unconstitutional because separate educational facilities are inherently unequal.
And the decision helped begin the end of legally mandated school segregation in the United States, even though the fight to make that principle real continued for many years.
A short sentence for a huge event.
That's Brown in a nutshell. A short sentence, a seismic consequence.
Today's episode is sponsored by Fyrebox. That's Fyrebox. Fyrebox is the no-code quiz platform trusted by marketers, teachers, and creators around the world. Whether you want to capture leads, run an assessment, or just engage your audience with something more interesting than a contact form, Fyrebox makes it easy. Start free at fyrebox.com. Welcome back. You just heard the story. Now let's see what stuck. Coming up, a few quick questions straight from what we just covered. 4 options each. I'll give you a few seconds to think before each answer. Ready? Here we go. Question 1. What did the Supreme Court rule in Brown v. Board of Education about segregated public schools? A. They were constitutional if facilities were equal. B. They were unconstitutional because separate educational facilities are inherently unequal. C. They were legal only in the South. D. They could continue until Congress passed a law. The correct answer is B. They were unconstitutional because separate educational facilities are inherently unequal. Question 2. Which earlier Supreme Court case helped establish the separate but equal doctrine that Brown challenged? A. Marbury v. Madison, B. Dred Scott v. Sanford, C. Plessy v. Ferguson, D. Gideon v. Wainwright. The correct answer is C. Plessy versus Ferguson. Question 3. Who wrote the unanimous 1954 Brown opinion as Chief Justice? A. Earl Warren, B. Thurgood Marshall, C. Harlan F. Stone, D. Earl J. Browning. The correct answer is A. Earl Warren. Question 4. What phrase did the Supreme Court use in Brown 2 in 1955 to describe how desegregation should be implemented? A. Immediate compliance, B. All deliberate speed, C. Equal opportunity first, D. Reasonable postponement. The correct answer is B. All deliberate speed. Question 5. Which social science research did the script say was part of the plaintiff's evidence in Brown? A. The Dole studies by Kenneth and Mamie Clark, B. The Kinsey reports on voting behavior, C. The Stanford prison experiment, D. The Hawthorne studies on factories. The correct answer is A. The Dole studies by Kenneth and Mamie Clark. That's a wrap on this one. Thanks for sticking with us all the way through, quiz and all. If you liked it, hit subscribe so the next episode lands automatically. I'm Cyril, this was the Quiz Fix, and we'll be back soon with another true story worth knowing.